Welcome back to Piercing the Corporate Veil, Lessons from the Docket. I'm Professor Seth C. Oranburg, and so far, we've covered a serious foundational element. When do courts pierce? We've discussed a two-part test, and we've applied it to both corporations and LLCs. Then we talked about both reverse and horizontal piercing as we got into some advanced topics. Today, in episode 6, we get even more advanced and delve into parent-subsidiary relationships with a focus on regulatory and environmental contexts. This is where corporate structures meet real-world accountability in high-stakes scenarios like pollution cleanup or safety violations. We'll explore key cases and principles that show how courts balance limited liability with public protection, building on Episode 5's sibling entity integration and setting the stage for modern applications in Episode 7. Parent-subsidiary relationships are common in modern business. A parent company owns a controlling interest in a subsidiary, allowing for operational separateness while maintaining oversight. Veil piercing here examines whether the parent can be held liable for the subsidiary's actions, and will especially look at under regulatory statutes when this can be true. The key tension is respecting corporate separateness while preventing abuse, often amplified by policy concerns for involuntary victims. So let's start with a landmark case. United States versus Bestfoods was decided by the U.S. Supreme Court in 1998. The dispute centered on environmental liability under the Comprehensive Environmental Response Compensation and Liability Act, or CERCLA, also known as the Superfund Act. This case involved a chemical manufacturing facility in Muskegon, Michigan, which was owned by Ott Chemical Company, which was acquired as a subsidiary by CPC International, which was later renamed Bestfoods. Over decades, the facility released hazardous substances that contaminated the soil and groundwater. The EPA identified the site as polluted and cleaned it up at significant cost to the federal government. So the government sued Bestfoods, seeking to hold the parent liable as an operator of the facility. Bestfoods argued it was shielded by the corporate veil, as it wasn't directly involved in the pollution, and that it had maintained corporate formalities. The Supreme Court clarified that a parent corporation is not automatically liable for a subsidiary's actions, not even under the Superfund Act, and not merely because of ownership. However, liability can attach if the parent actively manages or operates the polluting facility itself, beyond typical oversight. The court distinguished between permissible parental involvement, like monitoring performance, and direct operation, like parent employees managing the subsidiary's environmental compliance. The case was remanded for further fact-finding on whether Bestfoods crossed that line, and the ruling builds on our earlier discussion. It adapts the unity of interest and injustice test from Episode 2, but in a regulatory context where statutes like CERCLA can provide an independent basis for piercing without full traditional analysis. It echoes the undercapitalization risk in Casey from Episode 3 and the horizontal integration ideas in Episode 5. Subsidiaries in polluting industries must be adequately resourced to avoid pulling parents into liability, which highlights how entity separateness must be substantive, not superficial. Now let's turn to a private law case, Gardemall v. Westin Hotel Company. This was a 1999 Fifth Circuit decision applying Texas law. It was a wrongful death case that arose from a tragic scuba diving accident off of Cozumel, Mexico, where James Gardemall drowned during an excursion organized by the Westin Regina Resort, a hotel marketed under the Westin brand. The resort was actually owned by Desarrollos Quintas, a Mexican corporation, which had a franchise agreement with Westin Mexico, which itself was a subsidiary of Westin Hotel Company. Gardemall's widow sued Westin Hotel Company, the U.S. parent, and Westin Mexico, because the Mexican corporation was both difficult to sue and had little resources. The allegation was negligence in dive safety, but the defense, of course, was 1, a lack of personal jurisdiction, and 2, a limited liability shield. The defendant argued there was no alter ego and no relationship existed, and the Fifth Circuit agreed. It affirmed the dismissal and found insufficient evidence to pierce the veil. Despite shared branding and shared operational guidelines, these entities maintained separate finances. They had separate management. They had separate operations. They had separate bank accounts. There was no commingling of funds, and there was no undercapitalization to suggest a subsidiary was some mere instrumentality of the parent. The case highlights courts' reluctance to pierce in international franchise setups and, in fact, to pierce in general. And here there was no clear abuse. It contrasts with Bestfoods' focus on direct involvement and links to Episode 4's reverse piercing caution against undermining predictability. This was a pretty typical arrangement. Gardamel echoes horizontal piercing from Episode 5, where sibling entity liability requires very strong evidence of unity, here just applied vertically in a parent-subsidiary chain. In tort contexts like wrongful death, courts weigh involuntary victim harm, but they still demand proof beyond some mere affiliation, which emphasizes equity, not just automatic liability. Now, in regulatory environments, there could be statutes that could lower the piercing bar. So, under CERCLA, as in Bestfoods, operator liability can bypass traditional veil tests if the parent directly manages polluting activities, intersecting with environmental law's public policy goals to prevent parents from using subsidiaries as shields for foreseeable risks. So, we have an additional regulatory layer in that case because we have a federal statute, which obviously would preempt state law. Practically, businesses should ensure subsidiaries operate independently. It's always a good idea to have separate boards, separate finances, and separate decisions. Over-involvement, like parent executives directing subsidiary obligations, risks liability, and those liabilities can be veil-piercing or under some other statute. These are lessons that apply beyond environment to areas like antitrust and to labor. And we'll talk about that in episode 7, where we look at some gig economy, independent contractor, algorithmic operator, modern blurring of lines. So as we conclude, parent-subsidiary veil piercing attempts to balance corporate efficiency with accountability, especially in regulated fields where public harm is at stake. It reinforces that while structures provide protection, abuse invites scrutiny, tying together our series' theme of genuine separateness and fair outcomes. So let's talk briefly about our key takeaways. Parent liability requires more than ownership. Direct operation or alter ego must be shown. Regulatory statutes can facilitate piercing. Franchise cases emphasize maintaining separateness to avoid tort liability. We once again link back to undercapitalization and entity unity as core risks in corporate groups. And with that, I thank you for joining me. I'm Professor Seth C. Oranburg, and I'll see you in the next episode.